What's going on, guys, and welcome back to another video. Today we're going to be talking about Professor Gardner's legal argument, the first 4 chapters referencing the syllogism model. Got a lot of content to cover in 5-6 minutes, so I'm going to try and be brief. But before we get into the video, I'd like to remind you 100% of my viewers currently aren't subscribed to the channel right now, which is an astronomical amount. So if you could do me a favor, please go check that you're subscribed, like the video, say something nice in the comments. It would mean a lot. Anyways, back to it. So the syllogism model is really interesting to me, and it's the concept that Professor Gardner has that every legal argument could be based in the form of a syllogism. Now you're probably wondering, what is a syllogism? Well, I'm here to tell you. A syllogism is a 3-part statement which pretty much contains 2 premises and a conclusion. Let me give you an example. A syllogism, a simple one, could be, first premise would be, all dogs bark. Broad statement, talks about a general idea of something that happens, and then you say X is a dog. That would be your second premise, which is the applicable premise. That's the one that you apply to the first one, and your conclusion of that would be X barks, because you use the first 2, all dogs bark, and X is a dog. And if X is a dog and all dogs bark, then X must bark, and that's your conclusion. Very simple, in my opinion. It's a very simple concept. And, at the surface level, it's really easy to understand. So, yeah, it also follows like a commutative property, to where if A and B are true, and B and C are true, then A and C also have to be true. Why? I don't know. But that's what the book said. According to Professor Gardner, every good legal argument is in the form of a syllogism. I did have the pleasure of having Professor Gardner last year, and I'll leave it up to you whether you decide if that's true or not. Syllogisms can be false, even if they're logical, if the main premise is false. So if you say something totally wrong, like my dog is a cat, that's not true. Or all dogs are cats, or something like that. It doesn't really make sense, but it doesn't have to. Because it's a textbook. So the major premise is the statement, and the minor premise is the proposition. Analogies could also be a useful form of argument in law, but they're definitely less universal than syllogisms. Over relying on them could result in lengthy, kind of unfocused case descriptions, and we don't want that. That's not what we're looking for. We're looking for efficiency, simple, easy to understand, and you make your point, and it's a good point, a great point even. So next we're going to move to determining your conclusion from your position. So we need our syllogisms to be able to convince a judge to rule on our cases the way we want it to. Now, they don't approach open-ended questions, and we don't approach questions with an open mind. The position that we're in the case determines what arguments we need to make and how to convert them into a syllogistic form. We need to generate a set of presumptive positions on where we're going to stand, and then we're going to evaluate that set into what we're actually going to use in the litigation. Now, the position in a case depends on your client's alignment and the current law and situation that we have at hand. So the adversary system, which you all know and love, is our system of due process. Both sides get a chance to make their case, argue, counter-examine, and honestly, pretty fair. Gold star. Bing. The plaintiff must make arguments proving the defendant's guilt, and the defendant must oppose any arguments made by the plaintiff that would lead to the defendant's liability. Contractual liability is insisted on the fact that there must be a contract. So to make the point on contractual liability, the plaintiff must insist and argue that there was a contract. Very important. The more you know about relative law, the more you can flesh out your presumptive position. And once you have your set, you could actually choose which one you want to take and argue in the case. Now, we'll disqualify some of these positions because they're false, so we have to make sure they're true. And even true positions can be unsuitable for use because they have to be very persuasive because you want to win. If you don't have a very persuasive position, then it's just not going to work. So you really need to be careful and delicate and make sure that you're ready to argue like your life depends on it, because it might. Not every position needs to be defended by a good argument, or can be defended by a good argument. Most legal arguments aren't even for the main relief, but often towards motions and injunctions and DROs and other little steps along the way into the ultimate resolution of the case. And once you determine your actual positions, you can then begin to make your syllogistic arguments. Every advocate must firmly commit to the position in every single case. That's extremely important. You stay focused on what you're doing. That's the first couple of chapters, and we're at 5.5 minutes, so I'm going to cut the video short here and leave the rest of the information for another one. If you enjoyed the content in the video, make sure you leave a like, subscribe, write something nice down in the comments, and I look forward to the next one, and I hope you do too, because it's going to be just as good, if not better.